Hello, my name is Kristina Crump, and I am an attorney. I practice consumer bankruptcy law in Kansas and Western District of Missouri. This is my partner, Chris Coons.
Hi, I am also a consumer bankruptcy practitioner. Our law firm is Coons and Crump, and we only represent people in Chapter 7 and Chapter 13 consumer bankruptcies. We only represent debtors. And I think we're going to talk a little bit about the intersection of personal injury law and bankruptcy.
Yes. We typically divide those two into two different categories, the ones that happened, or the personal injury that happened before the case was filed and after. What are your thoughts on any cases or any injuries that happened before?
Well, if the injury happened beforehand and you're filing a Chapter 7 bankruptcy, that injury is going to be scheduled as a potential asset, even if it's not likely. If the debtor thinks there is a potential claim out there, it needs to be listed in the case so that the bankruptcy trustee is made aware of it, and it will be property of the estate. And there might be some exemptions that could be applied to the claim. But it's definitely going to be property of the estate, and the Chapter 7 bankruptcy trustee is really going to have a hold of that claim and of prosecuting that case. And even if the debtor has already hired counsel, the bankruptcy trustee will really have the say-so on how things are done.
Correct. When you say that it can have, or they can have control over what happens in the case, what exactly does that mean? Can they make the decision? Can they make settlement decisions on your behalf?
Absolutely. Well, it's not really even on the debtor's behalf, because the claim now, for the most part, belongs to the estate. Now, you could make an argument that portions of any claim could be exempt under certain theories. For instance, if a part of the claim is lost wages, well, there's an exemption in Kansas for wages. It's a 75% of wages owed. And so I think in theory you could apply that exemption to that portion of the claim. But that's not going to cover generally medical bills, pain and suffering, things like that. So that might only be a very small portion of the claim. And the bankruptcy trustee is essentially going to step into the shoes of the debtor and run that case. And so the personal injury lawyer that's handling that matter is going to be discussing it with the bankruptcy trustee.
That's in Chapter 7. So
that's
what about
in
Chapter
13?
13?
Well, in Chapter 13, let's assume the claim occurred before the case got filed. You would, once again, you'd schedule it. You would make sure the trustee is aware of it. And arguably, you would put some language in the bankruptcy plan. All 13s have a plan. You would put some language in the plan about the disposition of that claim or that lawsuit. Usually what you would say is, if this comes to fruition and there's some money later on, we will bring that back to the court and deal with that issue then, because you may also have some exemptions. But the debtor is going to be, to some extent, in the lead on prosecuting that case. And you're generally going to hire a personal injury lawyer if one is not already hired. In our office, we're going to file a motion to employ.
Motion to employ.
Yeah, and that's a very regular thing. Now there's a real argument, and I think one of our judges has held that you don't have to file a motion to employ, that it's not required. What's required is later on down the road you have to file a motion. We have to file a disclosure, motion to approve, things like motion to approve the settlement. But we feel that it's best practice for us to file a motion to employ.
And for everybody involved.
And for everybody involved, because it then puts everybody on notice that there's an active bankruptcy case. And in my mind, one of the reasons to do that is that the opposing party in a personal injury claim, if they find out there's an active bankruptcy and they believe there's been no disclosure, they will argue that through some theory of equitable estoppel, the failure to disclose the asset, the claim, precludes the debtor from pursuing the claim. So I like to get ahead of that and try to basically make sure that that's not an argument that some other judge in some other case is going to have to decide where I'm not involved.
What about post-petition or post-filing personal injury claims?
Well, in a Chapter 7, it probably falls into the not a part of this case category.
Doesn't matter.
It does not matter. Now, I'm gonna point out that in Chapter 7 cases, you can run into this issue about discovery of the injury. And so you can have personal injury or medical malpractice claims, or in particular, medical device claims.
Yeah, we had those mesh cases.
We had the mesh cases. And one of the issues in those cases were, when was the injury discovered? When did the harm occur? So you may have some cases where it is property of the estate. Maybe it should have been discovered earlier, or maybe it was remote, but it actually does not come up until afterwards. And you may have cases where it's completely excluded. It's simply not going to be property of that estate. But in a Chapter 7 case, injuries like a car accident that occurs after the case, that's not property of the estate. That's not going to be part of the estate. Chapter 13.
Oh, that's a different story, isn't it?
Yeah.
That's all over the place. In a way, I mean, it's property of the bankruptcy estate.
Right.
Because it comes, even though property that comes in later, but that did not exist at the time of filing of the case, can still become property of the estate if it's acquired while the case is open.
Yeah, that's correct.
But how it's going to be treated depends on the facts of each case. But the debtor has control over. Generally has control over.
I mean, we're still going to schedule it.
Right.
We're still going to do a motion to employ.
Give trustee the notice that there is an injury.
We're going to give the trustee a notice.
Do the motion to employ. That kind of puts everybody on notice again.
When the case settles, assuming it settles, we're going to do a motion to approve the settlement. And we might bifurcate the following thing, but the following issues. There's a difference between doing a motion to approve a settlement and a motion to retain a portion of the proceeds.
Correct. In our office, we bifurcate.
In our office, we typically bifurcate. And because we want to get that settlement taken care of, and we also want to kind of make sure that counsel gets paid. Counsel that handled the personal injury claim gets paid. And the court is going to approve any normal agreement. I've never seen the court not approve a normal agreement.
Right.
So that's going to get approved. But those funds that come in from those personal injury claims that come to the debtor are not necessarily, when they're post-petition, going to be paid into the estate.
Correct.
That's right.
But not necessarily entirely kept by the debtor either.
Absolutely correct.
Yeah, just depends on the facts, depends on how or what kind of injury happened, what was involved, are there future medical bills? I mean, there's 1,000 different ways to look at it.
Sure. I mean, I think that I've had cases where the debtors had a vehicle totaled in an accident, and there was insurance on the vehicle, but it covered the lender, and the debtor's running without a vehicle. We get a settlement in the personal injury claim, and the debtor then applies to retain the settlement, the proceeds of the settlement, in order to buy another vehicle. And the court has, essentially found that that's a reasonable thing to do. And in fact, in some of those cases, I don't even think the bankruptcy trustee has filed an objection. What they want is information. They want to know what's going on and what's happening. Where they have objected in a few cases have been to things like future medical expenses, future needs. And the objections that they file are not what I would call aggressive objections. They're objections filed because the trustee wants to get a record and wants to have a record of what is this debtor doing. And so we've had hearings with the court where the debtor has gone through and explained what's going to happen to the settlement proceeds. And then we've had the court rule, well, this is appropriate, and the debtor can retain these proceeds. And Kristina is absolutely correct that these are so fact-driven and so fact-specific and they're really case by case.
Absolutely. I think it's a mistake to think it's going to go one way or the other without really looking at the facts and
Well,
that particular case and bringing it in front of the court and the trustee.
Yeah, I think for practitioners, if you're a personal injury attorney, I think the thing that you have to be the most wary of is having a motion to approve any settlement or any payout on any judgment if it goes to trial.
Now, what happens if they don't get that approval?
Hair on fire, run out of the building, screaming.
Also, you just don't get paid.
You don't get paid.
Yeah,
No, you don't get paid. Oh, well, I mean,
There was a case, right?
Oh,
where
there have been a number of cases.
Yeah.
There have been a number of cases, but let's start with this idea, because I'll do you one worse than don't get paid. Get paid, and then 6 months later have an order of disgorgement, and you know,
against you, not the debtor.
Against you, not the debtor, and arguably against you for your portion of the money, and potentially for whatever you paid the debtor.
Correct.
Like if
that's
paid,
not enough, your portion is not enough.
If your
to cover
portion
the
is not
debts.
enough, right? You're an officer of the court. You should have known better. You should have gotten approval on any settlement before anything got paid out. And if you knew there was a bankruptcy case and you didn't do any of these things, you were probably on the hook. So
now, a lot of times our clients forget to tell people that they're in bankruptcy, or sometimes it just doesn't come up in the conversation.
Yeah, sure.
Is there a tool that you can use to figure it out for yourself?
Pacer. Pacer is the tool. That
10
is
cents, right? 10 cents a search?
10 cents a search. You know,
10 cents to send to like save thousands.
If you're a personal injury lawyer, please, if you don't have a Pacer account, you should have one. But if you don't have one, run and get one. It's easy. It's so easy to get set up. You have access to a system, and when people come in, run their names
Or social security numbers.
or social security numbers. Yeah, I mean you can run by social, but the other thing you need to be asking them is, you know, where have you lived, arguably the last 5 years? Because if they're in an active Chapter 13, it's unlikely to be running longer than 5 years, and so you want to have an idea, so you're checking, making sure that you're not missing an active Chapter 13 bankruptcy that's out there, because that's potentially a disaster. And if as a last-ditch effort, if you're an attorney in Kansas and you can't run a Pacer search, call us. We'll run the Pacer search for you. You know, there's a 20% chance it's one of our clients anyway,
That's
right?
right, if they're in bankruptcy.
25% in Chapter 13 in this state. So you really have got to make sure that you're checking on that, and Pacer is the cheapest form of malpractice insurance you could possibly get to save yourself. And yes, we have disgorgement cases in Kansas. You know, and
they're brutal.
And they're brutal. And I'm going to tell you that we'd have more of them, but we've been able to fix some of them in this office, because we've had this happen. We've had lawyers pay out on a claim when they shouldn't have paid out. And I had to call the lawyer and say, hey, you're on the hook for this. And the money's gone. And the only way we were able to save those cases, because this is all disclosed, we have to disclose everything, but we were able to save those cases through other process, which is called claims objection. I was able to reduce the claims that had to be paid in the case to a point where it got the lawyer off the hook for the money that had been paid out. I was able to get the claims really low. That is so lucky. That's like a Christmas miracle. And otherwise, I think that attorney would have had to pay out $60,000. I mean, it's just amazing. And that was arguably on top of the money they would have had to disgorge.
Right.
Yeah.
So Pacer checks and motions to employ.
Yeah,
Are your best
and
friends.
email and the telephone. If you find out that somebody's got an active Chapter 13 bankruptcy, the lawyer's going to talk to you. You know, reach out to debtors counsel and say, here's what's going on. Always make sure, it should be on your checklist, when you have an intake form, are you in an active bankruptcy? You may even want to ask if people are contemplating a bankruptcy, because in the case of a 7 or a 13, there are circumstances where, had we known there was a personal injury case out there, we might have been able to hold off the filing of the case until the personal injury claim was settled.
Oh, absolutely. I don't think I filed Chapter 7s with a pending
Active PI claims?
PI claim. Maybe a 13 if I have to.
I try not to, because those are cases where there's an active disaster like a wage garnishment or foreclosure or a pending repossession, and I may not be able to hold off on filing. But there are a number of cases that come into this office where we can maneuver the debtor to a point where they can probably hold off filing a little bit. And sometimes that means looking at some state court action. But, if they've got a pending PI claim, we want to advise them what's going to happen. What's going to go on. And you're going to want to know about it. If you're counsel in one of these cases, you're going to want to know if the debtor's financial circumstances are such that this is an issue coming down the road. I will say that in Chapter 7 cases, I personally have never seen a Chapter 7 trustee ask to have the attorney, the PI attorney, removed and put somebody else on the case. They almost always retain PI counsel that are already actively in the case.
Any other thoughts on PI?
I don't think so. But I will say that PI and workman's comp are treated very differently in the bankruptcy code. So for those of you that are doing both types of law, please understand that workman's compensation, those workman's comp cases are completely exempt under Kansas law. Of course, the dollar amounts are usually a lot lower. So you may have some different issues there. I still want to do disclosures. I still may want to do a motion to employ. I still think those things may apply. But I think the debtor is going to get to retain those funds. That's about it. Yep. That's probably the only thing I would mention.
Yep.
All right. That's about it for this issue.
Yep. Thank you.
If you need to stop creditor calls, harassment, collections, lawsuits, repossessions, garnishments, or foreclosures, please give us a call. Consultations are free.